Good morning.
Morning.
So my name is Oliver Geider. For the third day of the European Crowdfunding Convention this year, we are discussing today ECSP. That's the European crowdfunding regulation for or regulation for crowdfunding service providers. We have a very interesting panel today discussing the next steps in the implementation, the state of where we are, the legal text as it stands, and the room that is still there for maneuver by member states. We would start with a keynote by Diego Valiante, and then followed by a panel where Diego will be joined by Delphine Dirat from the French market authorities, Lynn from Seedrs, Pascal Ouvrard from Autorité, and Umberto Piattelli from Osborne Clarke. We hope that you have questions. Please use the Q&A session on the bottom. And I will hand over the moderation to Pascal and Jeff later on. But first, we would like to hear from Diego Valiante from the European Commission, DG FISMA. Diego, if you would join, and he will outline, I think, the viewpoint from the Commission as to the legal text where we are and what the next steps can be and will be. Diego, can you hear me?
Yes, I do. Good morning.
Good morning. So I will leave you to give your presentation.
Yeah, sure. First of all, thanks for the invitation, and trying to see whether I can, share my screen.
Yes.
I think you can actually see my screen now, and here we go. Can you all see it?
Yes, it's visible.
Excellent. Well, thank you, Oliver. Thank you to the ECN network for the invitation. It's been quite a long cooperation with you, and anyway, generally with the industry during this few years of work on the new European framework for the crowdfunding regulation. Now, what I want to do just today is, of course, not go through all the details of the regulation. There is no time. I mean, it will be just a short presentation, but I want to highlight some of the key parts of the work we have done so far and what's coming next, and some elements that could be more practical for crowdfunding service providers, platforms out there. Now, just very briefly, we have started this work already in 2016. The first questions on crowdfunding came up in 2013 in one of our consultation paper, but this work has started where in its full shape with the study that also ECN together with the law firm Osborne Clarke have done for us on studying the cross-border market barrier. Interestingly, 2016, our first report said that there was actually no merit for a European intervention at that moment in time. And it was generally true because the market was really so small and there was no actual regulatory framework being developed at national level. It was managed basically under existing laws. Then we started to see in the year after interventions by member states, but it's somehow very different types of intervention, which raise flags on essentially how can this be compatible with the cross-border provision of these services. And so we adopted a proposal in 2018 where we created 29 regime because, of course, we realized and we thought that there was a dichotomy between those markets and platforms that would remain national with those that would essentially join a cross-border type of activity. And that context, the 29 regime wanted to cover just those that wanted to go cross-border. But I must say, since then, there's been quite a lot of talks, and both the co-legislator converged on going towards a regulation and therefore a uniform regulatory framework for all types of crowdfunding services that are within the regulation, but whether they are provided at national level or provided cross-border. So this regulation basically will determine the way platforms are regulated, whether they provide services at national or at European level. And so in that sense, that the proposal then has been published recently in October after the the approval in second reading by the European Parliament, and is now entered into force on the 10th of November 2020. Now, the regulation is still not into application, which will come next year, 10th of November 2021, mainly because, of course, there is a process of having to digest, incorporate this regulation for the aspects that are not immediately applicable, and also for supervisors to get ready to issue authorizations, and as well to get already on the plate a number of level 2 measures that provides additional details. So we expect by November next year to have the regulation entering into force, especially for those platforms, for new platforms that don't need to be reauthorized. And there we received the RTSs, or at least the level 2 measures, so the detailed aspects of regulation that needs to be fleshed out by the supervisors through the ESMA by that time. And it will take some time for the procedure of endorsement, so will not be immediately ready to enter into force, but it will be probably a couple of months later. So we have also established a transition period, and before I go back to the level 2 measures that are being drafted at the moment, for new platforms, the regulation, as I said, will become fully applicable from November 2021. For existing ones, there is an exemption, derogation for application until the 10th of November 2022, unless the platform is being authorized earlier. And here, the Commission will make also an additional assessment on by the 10th of May 2022, whether to extend or further 12 months this derogation, general derogation. There is also a special derogation for 24 months after the 2021. The regulation will only apply for crowdfunding offers with a total consideration up to the threshold of publication of a prospectus regulation in those countries where the threshold of prospectus is below 5 million euros. What concerns what is coming in terms of level 2 measures, now, first I need to clarify that this is an ongoing process, so I cannot discuss specific drafts. This is still being developed, and there are actually meetings tomorrow at ESMA where we'll discuss the first drafts of this type of this level 2 regulation. But there will be a consultation early next year that will allow you to comment on actually these first drafts. So there is not an established date yet, but it will be in the first quarter of 2021, and so that ESMA will be ready to deliver the RTSs by the 10th of November 2021. As you can see, there are a lot of procedural aspects, so from how established procedure for complaint handling, conflicts of interest, business continuity plan, entry knowledge tests. So some of those will be delivered in November, some others will be delivered in 2022, included the official template for the keys, even though the level 1 text is already fairly detailed. So we when we drafted this, we believe that the market can start operations already with the details provided in level 1 text, but there will be a specific uniform template from mid-2022 to essentially establish specific rules on how this templates need to be drafted. Overall, I think these are, we have also some work to be done by EBA, in particular on credit risk assessment for platform providing individual portfolio management of loans. This is very important because there is details on how credit risk assessment should be done and disclosed, if there are contingency funds, etc. And as well on the information to clients in relation to how you score loans and price loans for investors. Now, what are the key elements of the proposal that are relevant at this stage? Of course, the ECSP provides a framework for authorization and operation and supervision of crowdfunding service providers. So we regulate the providers, but there are some requirements also for project owners. For instance, the key investor information sheet needs to be, the information needs to be provided by the project owner who remains liable for that information. And also has implication for investors, in particular, the ability to redress specific complaints. And so there are some spillover, I'd say, to other type of stakeholders too. Now, what we expect from the crowdfunding platform, that they actually operate as a neutral intermediary, and there are a list of requirements in there to make sure that there is no discrimination of clients, whether project owners or investors, unless there are specific requirements on how you select projects. Again, there should be no risk taking by the platform. There are no discretionary services unless you do individual portfolio management, but for individual portfolio management of loans, there are additional requirements that the regulations provide to account for this discretionality. Now, it is very important in your authorization process that you provide all the necessary information for the supervisory authority to take an independent and clear view of what your business model looks like, because based on that, they will be able to classify your the service that the platform provide in the different buckets that the regulation has established, and so the requirements. Another important aspect for the platform is the equal treatment of all clients. But of course, we have also put the investors in different categories, and the non-sophisticated investors will receive additional protection as necessary for this type of service. Now, what are the services that are being covered here? Well, there is the facilitation of granting of loans, where loans means an agreement with unconditional repayment schedule, so a very clear, simple type of loan agreement, and this is that does not apply to consumer lending, or at least to definition of consumer under the Consumer Credit Directive, which will take care. The upcoming review will take care of the consumer lending aspect of crowdfunding too. Now, where essentially we define consumer lending, all kinds of loans that are not for a business activity, whether it is a legal entity or a natural person, that doesn't matter. Is the objective of that loan that should not be for a known business activity, like renovation of a house or establishing a specific expense that is not related to business activity. Now, other services covered, as many of you already know, reception and transmission of order and placement of securities without firm commitment. So basically covers on the investor side the reception and transmission of orders from the investors, and and from the project owner side, the placement of securities without firm commitment, because essentially the platform does not take own risk on this. The license does not grant authorization for asset safekeeping and payment services. For this, the platform needs to seek additional authorization under the respective regimes. The instruments, as I said, we cover. This covers loan agreement, and in particular extends the definition of from transferable securities also to other types of instruments, like admitted instruments for crowdfunding purposes, which are essentially shares of limited liability companies with non-transferability constraints. This is very important, and again, on the definition of transferable securities, because in some countries the definition of transferable security already includes share of limited liability companies. This you have to refer to the national supervisors who will be provide you with the information on this. Now, there is a fundraising limit, so we have linked the application of the regulation to offers with total consideration above 5 million euros over a period of 12 months. We borrow the definition of total and consideration from basically the prospectus regulation. So you need to again discuss with the authorities what this interpretation is. All the rest will be outside the scope, will be governed under EU or national laws. Now, it's important that we think that the authorization, the single authorization as and the single terms of withdrawal, it's pretty powerful one. We think we created a system that is not a passport, so it doesn't need to have recognition, but this is a full EU-wide license. So you don't need to get authorization from the host member states where you are going to provide services. You need to inform them, obviously, but there is no authorization needed. And the host member states can only intervene in specific situations or where it has clear and demonstrable grounds for believing that irregularities have been committed by the provider or third parties designated by the provider. So we think this is a pretty powerful formulation. We'll see how this in practice will develop. For the authorization, we tried also to have a straightforward procedure. So you only have to get a recent decision within 3 months. I guess if you don't get it, you can start operation. There's no physical presence necessary in countries that is not the country of your authorization. There's also a framework of cooperation between NCAs and ESMA, etc. Other important requirements certainly is the prudential requirements. They are fairly limited, frankly, but they are there and need to be enforced. And they can be either in own funds or insurance, liability insurance, or a combination of both. Again, how to essentially make that calculation stays with the national authorities and with under the guidance of EBA. Now, for what concerns the secondary markets, which are an important part of many of these businesses, we only allow the operation of a bulletin board, which is essentially a simple advertising of interest, buying and selling of loans. And we expect that if the crowdfunding platform wants to do more than that, wants to start to match these interests, then we need to seek authorization as an MTF under probably under the MiFID framework. Now, I'm not going to the details because there are some elements about pricing, etc. But overall, I think that the regime here is clear what is the stance is from the European regulators on that. There are some requirements on marketing communications because we are aware that marketing rules, national marketing rules, are being regularly used to curb activity cross-border activities of platforms, but anyway, generally also in other financial services areas. And so we have introduced requirements there to make sure that as provider that provide service cross-border, you can access those rules and actually interpretations of the rules by the national supervisors in a way that you can comply with these marketing rules without having to seek expensive legal advice. Now, there is also a system of reporting requirements. It's very light regime. It's not a trade reporting a la MiFID, but it's just an annual disclosure of what kind of projects, amounts, etc. We need to establish a minimum level of disclosure, an aggregate level on how these markets develops, and something that is reliable and not based on surveys. Now, finally, and I'm going to close, we have also a set of investor protection measures, as you probably already know. We have a criteria for the classification of sophisticated investors, which are basically those that are non-sophisticated. The non-sophisticated is basically as the residual category. So you would have to opt in to be sophisticated investors. We rely also on the fact that there's a lot of inertia by investors. Investors will not typically opt in for sophisticated investors unless you really are a systematic professional like investor in this type of investments. A lot of other things which I'm not going through. Just I want to focus a bit more on the key investment information sheet. We are developing already, even though the deadline is not in 2021, the template for the keys. We are aware that there is a lot of information to be disclosed, and keeping in 6 pages could be a challenge, but there is a limit there, and it's a hard limit. Now, most importantly is the liability. We made sure that the project owner stays liable for the actual content of the information disclosed. There is a bit of confusion for some that are reading the legal text about whether this liability spills over on the platform, but I can tell you that the rationale, and this has to be, of course, properly clarified, probably later on in Q&As by ESMA or IBA, we'll see. But the rationale there is that there is a limited liability for the platform in relation to make sure that the template, so the information is being requested, is properly filled in, that is correctly filled in, and so that you don't put, your legal name somewhere else in the template, so that template reflects the correct order of information and information that is not grossly wrong. Okay, so that type of liability stays with the platform, but of course it's not about the actual content of that information disclosed by the owner. And if there is no knowledge by the platform that the information is wrong, then there is no liability there. Then there is an additional keys at platform level for individual portfolio management, because there we have essentially a more pooled risk, and therefore we need also some level of pooled disclosure by the platform. So I will close here, and I look forward to the discussion, to the questions of the attendants. Thank you.
Pascal, I think you're on mute.
Yeah, thank you very much, Jeff. So thank you very much, Diego, for this recap on this long-awaited text by all platforms. It's very, it's very satisfactory to see that indeed this legislation is, this regulation is recognizing the importance of crowdfunding in all member states in Europe. And we are all looking forward to start working on drafting the necessary documents to obtain this license. First of all, I would like to, for each of my co-panelists to introduce themselves, and then we can go into some more questions about the next 2 years and the RTS. And there are already 2 questions from the audience that we will, of course, try to answer. So maybe Delphine, if you could start by introducing yourself.
Sure. Many thanks, Pascal. So my name is Delphine Dirat. So I've been working for the IMF since 8 years now. So I was there for the creation of the French regime 6 years ago, and I was also seconded to the European Commission during 2 years actually. So I also know quite well this crowdfunding regulation. And I came back to the IMF 1 year ago, and I'm the head of the unit in charge of issuers, and so my unit is in charge of crowdfunding. So I'm very happy to be here to explain what we are doing as authorities, and also to hear your questions.
Thank you very much. Jeff, maybe?
Great. Hello, everybody. And nice to see many of you again after Tuesday. My name is Jeff Lynn. I am one of the co-founders and now executive chairman of Seedrs. We are a UK-based equity crowdfunding platform that has had a long-standing interest in the European market. I was very privileged to work together with Pascal and a number of the people on this call in ECN and with Diego and others, through the ECSP process. Very excited about the opportunity that this provides, certainly for my own platform, which is in the process of a merger with another UK platform, Crowdcube, and post-merger, we're very much hoping to be able to dual headquarter ourselves or dual regulate in Europe and be, participate under the new regime. But more than anything, just really pleased to see the tremendous advances under Diego and the Commission's leadership that came in this proposal, and what it's going to mean for European crowdfunding in the years and decades ahead.
Thank you very much, Jeff. Umberto?
Hello, everybody. Thanks, Pascal. I am a partner at the international law firm Osborne Clarke. I am an expert in financial regulation, so say all of this kind of matter. And crowdfunding was one of the main regulation area where we were looking as a firm. And I was personally involved as a member of the European Crowdfunding Stakeholder Forum back in 2014. Which was formed by the European Commission to put together 40 advisors from different jurisdictions to start the process, which in the end led to the publication of the regulation that Diego was before representing to us.
Thank you very much, Umberto. Maybe Matthias? No, Matthias does not want to introduce himself. Okay, well, we'll proceed further. So again, thank you very much, Diego, for summarizing not only what has happened to come to this point where in November there was the acceptance of this new regulation, and also to explain what is going to happen in the next 2 years. Certainly, the platforms are also eagerly waiting for the clarifications that will be introduced with the RTS. And maybe one question to both yourself and Delphine is to how have the local regulators been involved in together with ESMA to help provide input into those RTS?
Well, I don't know if you, for those who are not familiar with the framework, and probably Delphine can say more, actually, Delphine should answer that. But I just quickly say that the ESMA has set up a task force, crowdfunding task force, who is actually drafting the level 2 measure. But this task force is made of national supervisors. So there are individuals coming from national authorities who are actually involved together with few officers from ESMA in the drafting of the level 2. So they are involved as much as they can possibly can do. So that's what it is. Maybe Delphine can say a bit more on that, you know.
Yes, no, thanks for the Diego. Yes, so exactly. So the IMF is currently working with other national authorities at ESMA on the drafting of the regulatory technical standards. So the objective is to provide some technical details about very important topics such as the KISS, in particular the format of the KISS, the entry knowledge test, or even the application for authorization. So the objective is to launch a consultation period in March. So normally it will be open for 3 months. And I really like to encourage you actually to participate in this, you or your industry actually, or the ECN, to participate in this consultation, because I think it will be very helpful for regulators and ESMA to have your input and to have your concrete examples on what can work and what cannot work. So I really encourage you, if you can, to read the consultation and to provide either your authorities or as directly ESMA with concrete examples and feedback.
Thank you very much. Can you maybe remind us where we will be able to find this consultation, where it will open, so that we can answer?
Yeah, well, it will be generally, this is published on ESMA's website. So this is why you can answer to the consultation. Yeah, well, I think we will put it on LinkedIn, but yeah, it will be on the ESMA's website.
I think it is going to be very public on ESMA website.
Okay, great, thank you. All right. So there are certainly some aspects which you know will need to be clarified, and one, for example, that comes into mind is Article 21, where there are some of the criteria which are stated between the entry test and the simulation are not always the same. And I know that I've had questions from other platforms in that direction. Will one of the objectives of the RTS will to clarify such gray area or divergence in terms, Diego?
Yes, I mean, to some extent the law is pretty detailed. The level 1 is already pretty detailed. The level 2 will probably provide additional details on how you define income, etc. But do you have very specific questions on that? Because I don't know what you're referring to in parts that are saying they're not harmonized or they're not clear.
Well, for example, on the entry tests, I don't have the text under my eyes, but it states some criteria, whereas the simulator quotes other criteria, and one would have assumed that the entry test and the simulator are intertwined and therefore should be based on the same type of information, which in this case,
yes, but they're consequential. So the first you need to do the entry knowledge tests, and then you do the simulation test. And part of the information that you gather from the knowledge test should be used and can be used for the simulation. But as I said, the simulation requires additional information to be run. So, but again, I mein, these are all. It's all a framework where there will be also some level of flexibility by the supervisors. So, I would expect them to give you more details on how to set up the actual test. Now, I mean, we have provided some level of general details that are important, but the actual detail, how you define income, as I said before, what are the elements of income that you will be asking is to be done at national level. And even if the level 2 has not intervened, in the meantime, you can still start operation based on the guidance of the national supervisor until you have then the level 2 that gives you the exact details on how to do that, and you will make the modifications. But again, I don't think these are. It's a major issue, because there is no let's say, how do you say this, restriction to access attached to these tests, and that to some extent should be factored in.
And to what extent, platforms who have been existing for a long time, Seedrs and Crowdcube certainly come to mind. We've been in existence for over 5 years. To what extent should we have all our existing registered and active investors or lenders go through that entry test again, even though in some existing regulations it already exists, and to this simulator? Is there some sort of grandfather clause applying to active investors and lenders, or will they have to go through it all over again?
No, when you go to the reauthorization, you're basically, for the supervisor, a new entity. Now, we facilitate the process of reauthorization in the way that you don't need probably to disclose information that the supervisor already holds. So the supervisor will ask you for a customized set of additional information to make you compliant with the new regulatory framework. But that means that all new projects that are being on the platform will need to be compliant with the new regulation. Therefore, the investors that enter into these new projects will need to be also facing this entry knowledge test, etc., and have this opt-in procedure for those that are sophisticated. So that process needs to be done, but it will be done once, and then you will have just an annual review if necessary, etc., according to the article requirement.
Okay, thank you very much. Delphine, this one is more for you, because you are, representing the EMF, and in France, we are one of the few countries where there are 2 regulators that are supervising platforms. So the EMF for equity platforms and the ECPR for loan platforms. That is also the case in few of the member states. Without revealing any final decision, which I understand might not have been taken or might be confidential, how do you anticipate, applying to the single point of contact, which is stating in the ECSP in cases like that?
Yes, so well, as you know, actually, the regulation provides for only one single point of contact. So it's true that in the case of countries where you have 2 authorities, we will have to find an articulation between the 2 authorities. So this is still something that we are reflecting with the ACPR and the French Treasury. So yeah, I cannot reveal anything for now. Well, this is likely that well, as the EMF, maybe it could be the EMF, because we have this direct link with ESMA, so it could be a bit more natural. But even if the EMF was designed the single access point, of course we'll have to articulate with the ACPR, because we do not have the expertise in terms of lending-based crowdfunding. So we will have to find a cooperation. So in any case, to me, it will be only an administrative access point, because in practice, this is clear that we will have to coordinate among the 2 authorities.
Great, thank you very much. Umberto, maybe this one for you. Within at the latest November 2022, platform will have to prepare the necessary documents in order to submit that to the regulator, whether they are new or existing platforms. you know, if I am responsible for a platform, I might ask myself, well, will I need to involve the lawyer? How complicated is it going to be? So maybe you have some, you know, some information about that, or your thoughts.
Yes, thanks, Pascal. As Italy was regulating, you know, especially equity crowdfunding matters from early 2013, we have an extensive experience, because part of the regulation and the law existing in Italy are now included in the provision of the new regulation. You know, the keys was already existing in Italy, even if a little bit shorter, but the principle was exactly the same. We have been involved in assisting many of the Italian platform applying for a license. To be honest, it was a little bit easier at the beginning, but year after year, the process has been changed, and it's now, to be honest, a little bit more complex. And by looking at the existing Italian regulation compared to the new EU regulation, I see that there is much more complexity in the end. So I see very, very difficult that this kind of authorization can be obtained without proper advice. I would say, of course, from lawyers, but you know, there will be also prudential requirements from now on, which means also some, you know, good advice on how to draft your business plan, how to, you know, present your financial and economic capability over a reasonable period of time, 3 years, 4 years, because this is something which may have an impact when the regulator is going to look to the possibility to grant a license. So it's not only a matter of checking formalities. So if you have all the requirements and the organization to do the business, but it will be also looking into the capability of any platform to be able to support the business without you know, running out of money and creating issues to the investors.
Hey, can I perhaps jump in with a slightly general question that Umberto's discussion sort of prompted in my mind, and this may be one for Umberto or Delphine or Diego. But you know, the Italian crowdfunding regulation was a very interesting experience, because at one level, you know, it was a huge accomplishment and a huge signal from Italy to have pioneered quite so early in the development of crowdfunding a bespoke regime. And I think it was very much, I remember very much welcoming it as an industry at the time. But I do think, with greatest respect, that you know, the general consensus is it didn't quite work, because in part because it was designed before, you know, we really understood, you know, a lot of aspects of how the market would develop. You know, there are a number of aspects of it that wound up being not entirely fit for purpose, and the Italian crowdfunding market hasn't grown to quite the extent that maybe it might have. Now, you know, there may be those who disagree with that, but from that base, I'm just interested in how we're thinking about future evolution of the ECSP. I mean, it's a little bit, I appreciate it's a little bit premature. We're not even implemented yet, but at one level, you know, the ECSP has the advantage of the years of studies that the Commission did, that Diego highlighted, and a much greater understanding of the market, you know, by the time it was implemented. But I think that there is a reality that things will change, and it'll turn out that, you know, even those of us who were advocating for this provision or that provision, you know, got things wrong. Some of that will be, you know, can be dealt with through RTS. Some of it can be dealt with through clarifications from ESMA and the EBA. But as we look to 2022, 2023, you know, if we begin seeing aspects of the regulation that just don't quite work, I'd be interested, what's the process? You know, from a technical perspective, would it require a whole new, you know, a whole new regulation to go through the Commission? Are there other solutions that can be put in place? How do we amend, adapt, and basically ensure that this great new regime sort of remains fit for purpose as the market develops? As I said, that's for anybody.
Yeah, if I just may add a very quick comment, you are not that wrong. What happened, in my opinion, is that to be the first was good, but there was a lot of concern from the regulators and from the Italian government. So the idea was to issue the most restrictive law in the world, and they did it. So what happened after that? Every single year after 2013, the law and the regulation has been amended to, listening to the request of the markets. And now it's almost, I would say, perfect, let me say. But what is really strange is the Italian regulation is now much wider than European. We have the 8 million euro limit. We can offer funds. We can offer mini bonds. Holding company can apply and then get the money to invest in other businesses. So it's quite strange, in the end, when the regulation was, I think, fitting with the market request. It's too late because now the regulation is changing again. So Italy made this experience.
On my side, well, what I like to first say is that, well, the IMF supported and welcomes the adoption of this European regulation. And I really believe that 6 years after the implementation of the French regime, this is the right moment to harmonize national crowdfunding regimes and to allow or facilitate cross-border activities in Europe. But it's true that, well, we also acknowledge that this text represents an opportunity, but also some challenges for crowdfunding platforms. In particular compared to existing national regimes. Of course, it may require, and I will not lie, it may require business model adaptation, website restructuring, new investor paths, and also new legal considerations. So I also understand that well, this is complicated for platforms, and I would like to also to mention here that the authorities are also here to help platforms understand this regulation. The fact that the supervision was given to ESMA was given, sorry, this is a lapsus, was given to national competence authorities, of course, can create a couple of discrepancies. We do have a lot of discussions with other national competent authorities in order to because we do have some questions about the text. Some aspects are not so clear for us as well. So this is why we have ESMA, and we plan to send a couple of questions to the European Commission in order to also better understand the text. So yeah, this is maybe a limit, the fact that supervision was given to NCAs and not to ESMA as proposed by the European Commission, because it's true that we will have to coordinate among ourselves to find a common understanding of the text. But well, having said that, I think that we authorities, we are ready to help platforms and to also try to answer your questions. And well, starting a regulation with mentioning that we want to change it is maybe a good start. So I will propose to start with the regulation that we have, Jeff, and of course to see with the experience what we can change. Well, you know that the text is well done in that aspect, because there is a review that is foreseen, and it will come actually very early. So let's see if there is a need for more guidance or specific guidance. We can also do what we can level 3 in our jargon. So Q&A published by ESMA, or this kind of tools we can also use. So we will try to be very specific in the RTS, and we hope that it will be enough. But if this is not enough, of course we will push ESMA to publish some Q&As. I don't know, Diego, if you want to say something. Or...
Yeah, I mean, you pretty much said everything. Just one point. I mean, it is true the regulation might not be perfect as any regulation. I'm sure there are a lot of imperfection in the Italian framework too. But I want to emphasize that we are actually a multi-layer regulators. So there are level 2 measures that can introduce some level of details that can adjust for potential implementation issues. There is a Q&A framework developed by ESMA, which is pretty powerful in providing interpretations that could be used by platform without having to resort to a legal advice. And so there are also national supervisors that, I don't know for France, but there are certainly national supervisors that can provide suggestions, guidelines on how to implement specific rules and what kind of information is required to a level of detail that doesn't require legal advice. So I don't think it is a complex framework. So I'm not saying that you don't need legal advice. You might need legal advice, or you might not need legal advice. It also depends on whether you have a legal counsel in your practice that can help you with the authorization process. It depends from many factors. Now, it is a framework that takes into account, frankly, that this is a EU-wide license. It's not a national license anymore. It gives you the possibility to offer to the public up to 5 million euros cross-border. I mean, we are breaking the boundaries of national of countries here and giving you basically a 400 million plus market out there for this type of services. So it has to come with as a regulatory framework, and this is what it is. And I'm sure that in our review that will come in 2023, there will be adjustments may be made to the level 1. But before we get there, there are a lot of other steps that can be taken to account for potential issues with implementation. So far, all the issues we have encountered, also from what we have heard, are all manageable without having to review the level 1. But we have to see how the whole framework applies. I said already, I sent some signals about the keys and the size of the keys, etc. If it remains within the boundaries set by the law, etc. If there are issues there, but it will come down the road.
That's very helpful. Thank you. I found that actually hugely informative. And just to be clear to all the attendees, in case it wasn't apparent from my question, I'm not asking this because I think there are problems. To the contrary, I mean, having been involved in tracking this and helping to support this legislative process since 2017, I think that the outcome is as good as could possibly have been developed, and I think it does provide to my mind a fully workable and hugely exciting and effective regime. I ask it more out of an almost academic interest about how do regulation and innovation keep up with each other, and I think this will be one of these. This will be a great sort of almost testing ground for some of those challenges as new people innovate and come up with new models. How does further engagement occur? But I certainly don't see a need for change now, and by any means. And the most important thing is getting to 10th November 2021 and getting things into action. I'll also jump in to say I know that I just a little more back down to some of the more specifics. We have a few questions piling up here in the Q&A, and I thought maybe it would be worth ticking a few of those off as we go, and then Pascal, if you have additional questions. But Matthew Carana asks about commissions and the ability of CSPs to charge commission, and I know it specifically points out that Article 3 says CSPs shall not pay or accept any remuneration, discount, or non-monetary benefit for routing orders to a particular crowdfunding offer made on their platform or another a third-party platform. Does that mean that CSPs can't charge a commission on funds raised? Of course, it doesn't. Commissions are going to be the normal fee structure, but maybe one of the people with more technical expertise can explain what this provision does do.
Yeah, maybe I just maybe I will ask then maybe Delphine if he wants to say something. But this is a general ban on inducements by third parties. So we don't want that people are not clients are using financial means to distort your neutral role as platform. So you can charge project owners, you can charge investors, but you should not receive payments from third parties for service they are not providing to them, but just because you are steering investors to specific projects, or you are essentially giving a privileged position to a specific type of offers. And so that's what it is. Pretty simple terms.
That makes sense, and Matthew, please do chime in if you want to elaborate further. Lisa, I think I may hold your question on secondary market technicalities at least for a moment, because there are a lot of them, I'm conscious, and it may take a little bit of while to delve into them, but we can come back to it. But Karsten, you posed to Delphine the question about interaction between national regulation and the ECSP. I think at a theoretical level, we know a lot. We know that ESP is a regulation. It does trump a national regulation, so to speak. But the specific example you give is, we've got a 4-day reflection period in ESP, but two-week reflection in German law. Do we envision ESMA clarifying that the ECSP is the exclusively applicable in these kinds of cases?
Yeah, well, this is a good question. I think that, of course, the scope of the existing national regimes may be different from the scope of this European regulation. Well, my understanding of the regulation is that it will delete national regimes, at least for all the activities that are within the scope of the regulation. But for example, in France, our national regime also covers donation-based crowdfunding, and it's true that for this kind of activities, we don't know whether we will maintain or not a national regime. So I think that there are lots of reflections within authorities about activities that do not fall within the scope of the European regulation. But for me, activities that fall within the scope of the regulation now, of course, are governed by the European regulation. So I guess that for this particular question, my understanding is that the European regulation will apply, and the national German law will have to be changed, and this part will have to be deleted, but to be confirmed, of course, by the BaFin. But this is how I see the articulation between the national regimes and the European regulation.
Yeah, I mean, this is a lex specialis, so it enters the national regime, and so it doesn't need to modify necessarily the national regime. It applies for this specific service covered by the regulations, and so the German law will not override the European rules, and so will remain applicable for the services that are not covered by the regulation, but will not be applicable anymore for the service covered by the regulation. And I can assure you, there's been quite a lot of discussion with the German Justice Ministry during the trialogues to make sure that they were happy with the current text on this part, in particular, about the reflection period. So it's there, and therefore essentially is the only rule that is applicable.
Great, that's, I think, very clear. I'm going to skip ahead to Johannes's question, because it's one of particular interest to me as well, and then I'll hand back to Pascal and make sure and we can continue going from there, and we can get back to the rest of the Q&A toward the end, perhaps. But Johannes asks, in the area of investment-based crowdfunding, regulation must, by its very nature, focus on national company law. From your point of view, is there a great risk that the implementation of the national authorities will indirectly lead to the regulation not having the desired effect? Now, I think that's a broad question, and there are probably a number of permutations in which that could become relevant. But I'd be very interested in hearing views on, on current thinking around the concept of admitted instruments for crowdfunding purposes, because one of the big discussions that came up, I remember, over the course of the legislative process was what securities were covered here. And I think the original draft envisioned that like MiFID, it would be limited to transferable securities. Problem is, there isn't really a particularly good definition of transferable securities, but in many countries, that is basically limited to the public company form. It's the AG or the equivalents in various places are what those countries deem to be transferable securities. And as we all know, the kinds of small, medium-sized enterprises that are most likely to use crowdfunding often don't use those forms for very good reason. They use the GmbH, or they use the sort of private company form that's applicable in other places. So, a compromise, I know, went through a number of iterations, but that ultimately settled on the idea that the regulation applies both to transferable securities and admitted instruments for crowdfunding purposes. And certainly to me, one of the big questions is, how broad is that actually going to be? Is it going to cover things like the GmbH and the equivalents in other countries, that tend to be used by smaller companies? And how much do we even know at this stage about how that's going to play out? So I don't know if that's for Diego or Delphine.
Yeah, I mean, we worked hard on this because there is some level, as Carsten correctly, was Carsten or somebody else pointed out in his, is that essentially there is a level of interpretation of the EU law at national level, and even if it's a regulation, there are some details that could differ from a country to another, and including the supervisory practices could be different. The point is that there is a definition now of transferable securities at European level with MiFID. This definition has been applied in different way because, for instance, many countries like Finland, a limited liability company share is a transferable security. In countries like Italy or Spain, a limited liability share is not a transferable security. But in crowdfunding, shares of limited liability company are probably the vast majority, if not totality, of the type of equity that is marketed on those platforms. So we made a clear choice, and has been a political choice made by all member states, to have this type of instruments to be included all across the EU, precisely because the definition of transferable security is not uniform, that we have introduced this concept of admitted instruments to make sure that in countries where the shares of private limited liability company are not transferable securities can still be captured by this regulation, with the caveats that have to be transferable share. Now, what that transferability means, there we leave interpretation. Why? Because there are many different legal systems, and the concept of transferability could actually change. Now, we expect that, for instance, the fact that there is a notary authentication is not a constraint to transferability, but this, again, are interpretation that would need to see how they play out in practice. So this might mean that the national member states might actually introduce changes to the civil code to make sure that we makes as easy as possible the transfer of ownership of this type of shares. But again, we are touching boundaries where there is the competence is of member states on private laws, and where especially standard private laws, that where the commission, or anyway the commission, has not taken a full let's say stance. So, but we don't see this as a major issue. And remember, this is a EU-wide license. So if you're offering that product, and that product is essentially offered from country A, where that instrument is fully recognized, even as a transferable security, you can market that anywhere. And so in some sense, you know, that type of this licensing framework facilitates also the fact that you don't have to read all the definition of transferable security of 27 member states. You just need to focus on the country where you are actually authorized. And again, if they recognize this instrument, then this instrument can be marketed across Europe.
Yeah, maybe just to, no, sorry, go ahead.
Just to add a little bit of background from what happened in Italy, we went through exactly this process because limit liability quotas were not considered as transferable securities, but it was the special law dealing with crowdfunding which was opening to this opportunity. And given the fact that in Italy, a notary is required to make a transfer of the kind of securities, the law was changed in favor of the platform to allow the platform to become a kind of fiduciary, I wouldn't say owner, but basically this is what is resulting, you know, from the law, just to keep the securities in the name of the investor and allow them to transfer without the need to go to the notary. So it was a great improvement because it was reducing a lot of expenses and also taxes, which were not applicable to this case of transfer. So maybe this can be a piece of experience which later can be reused by other jurisdiction and allow platform to gain a more important role in the managing of the crowdfunding transaction and what happened after the investment.
Yeah, I fully subscribe the fact that this we need to learn from successful experience, and this probably was one of the successes of the Italian trip.
Maybe just a few words, but just to conclude, because I think that everything was already said. But first, I want to say that the fact that we do not have a clear definition of transferable securities, as mentioned by Diego, is a bit business as usual for us. So it's not particular to crowdfunding. We already know that we have different interpretations across Europe, and also to mention that this admitting instruments. Also, the fact that each national competent authority will have also to analyze whether or not they allow the offer of some admitting instruments at the moment of the authorization. So just to mention that this is at the moment of the authorization of the process that we will analyze all the instruments that you plan to offer, and this is where we will of course tell you whether or not you could offer the instruments. In France, we are still thinking about mini bond and whether or not they could be covered by this regulation. So where this is under analyze, and I think, but I'm sure that we will communicate, and I think it will be the same for other authorities. They will communicate about this more specific instruments and whether or not they can be covered by the regulation. But this is on our agenda.
Thank you very much for the clarification on this very important point. Maybe I will take the next question. One of the anonymous attendee was requiring a clarification on the monitoring of the implementation of ECSP in the member states, and whether this was going to be undertaken by DG FISMA or by ESMA, and whether there was a timeline for that. So maybe again, Diego and Delphine, if you want to
sorry,
comment
can you I just missed can you please repeat? I couldn't hear your question.
Sure. It was about the monitoring of the implementation of ECSP in the member states, and whether that would be done by DG FISMA or ESMA.
This is type of activity that is done by the Commission, because the implementation of the law is mainly followed by the Commission, but the Commission will rely on ESMA as well to collect information and to the ESMA network. But the enforcement of the EU law stays with the Commission. Now, there are also some tools that are delegated to ESMA, like peer reviews, etc., on how the laws has been implemented. But these are more specific, and usually they are used when the framework is already well developed and has been in application for some time.
Delphine, any additional comment on that question?
No, I think
it was
it's
pretty
the same
clear
for all,
what I could see, but
all regulations. What I see in this regulation, which is specific, is that we, as authorities, we do have a lot of reporting to make to ESMA. So I actually think that it's going to help in terms of cooperation and articulation and common understanding of the rules. So on this aspect, I think that the regulation is very well made, and we will have a lot of interactions with other authorities. So this is a good point.
Great, thank you very much. Maybe we have a bit of time to come back to Lisa's question, if you also agree. There has been a lot of discussion certainly in the preparation of the text about the secondary market and what it should or should not involve, and even whether it should even exist in the text. We have it currently in its existing form as a bulletin board, which certainly for platforms which have developed a whole activity on secondary markets will be a hindrance, but at the same time also offer some opportunities to platforms who have not implemented such quote-unquote secondary market. So Lisa asked whether we could have some elaborate on the technicalities for the issuance platforms. I would add personally to that question also on loans, because as I can certainly understand, like for any other stock markets, that a transferable security, you can have volatility in the price, and you can have ask and demand. The parameters for loan are kind of set at the moment the contract is emitted. So where this the current text englobes in the same manner equity and loans, if you, without going into lengthy details, but if you could provide some maybe clarities on how you see this functioning in reality for both type of financial instruments.
You ask me again. I think I'll need to ask you to give you a bit more details, because as we said, we provide also a different framework to some extent for loan disclosure. Now, when it comes, for instance, to secondary markets, I agree the pricing it's somehow fixed, but we think that the text is flexible enough not to overburden platforms that deal with loan with information that is not necessary. Now, unless, as I said, there's a specific situation that you have encountered where you think there is unnecessary disclosure because we are imposing on new requirements that should not be imposed to lending-based platforms. But let me also emphasize one point. This is the first framework that I'm aware of where there is a clear possibility to merge multiple models of lending-based and equity-based. We encourage platforms to become one-stop shop platforms where you can provide firms any kind of type of finance, whether it's equity, whether it is lending, where it is any type of hybrid funding. So in some sense, the framework has been designed with that idea in mind. Now, the fact that there is only one point of contact means that there's also the need for the supervisors to come together, not to issue separate license. So there will be one license. That license will cover both services. And so in some sense, we want to stimulate that type of understanding. Why? Because technology now reduces the possibility for, increases the possibility to customize this type of services according to the profiles of the companies that are seeking funding. And so we want to ensure that, and there are some platforms across Europe that have started this type of business model. And so we think that this is a good approach. Now, if there are requirements that you think are not necessary or are badly designed or not designed to take into account the differences between loans and equity, we're happy to hear any of this, and if necessary, provide the changes that are required at level 1 when the review will come. But I'm not sure I see that. But again, I'm afraid that you don't want to go into this, but you will need to tell me more if there is a specific area where this is happening.
Thank you very much. I think it will definitely open opportunities for platforms to become, as you have outlined it, one-stop shops. Umberto, I believe you would like to answer the next question.
I was writing a very short answer about the issue of the non-security tokens. I guess that, well, first of all, we know that the crowdfunding regulation at the very beginning was involved in a discussion about including or not tokens or similar digital assets, and the decision was to keep this outside from the regulation. At the same time, we need to remember that there is a very important piece of regulation coming from the EU about virtual currency tokens, which will be regulated according to new terms and conditions, and will be a very extensive regulation. So I guess that till the date in which we will have this piece of regulation available and in force, it will be very, very difficult, to mix these two areas. There may be, of course, some kind of interactions between crowdfunding and tokens, but I guess it's really, really too early to speak about that. I think this is something to be understood at a later stage, and it may be an opportunity, but it's very difficult to say which kind of interaction can be, imagined or predicted before the regulation is issued by the EU.
Yeah, and if I might add on Umberto's remarks, I mean, he's completely right that we don't cover security tokens. And there is also an additional proposal, the DLT pilot project, that will also be applicable in case a platform might decide to enter the space of DLT, tokens. In that space, then there's both MiCAR and the DLT-based infrastructure, which a platform is once it decides essentially to issue these security tokens. But I would also see this regulation as a sort of additional layer that could be applicable on the current crowdfunding framework. Why? Because the type of requirements that are imposed for in MiCAR and the DLT pilot projects are requirements that are tailored for the DLT dimension of that instrument and that issuance. So in some sense could be an additional layer to put on top of the crowdfunding regulation. And the fact that the crowdfunding regulation is a regulation and provide a new license, it makes that combination even easier, because of course it will be that supervisor that will also make the assessment whether you are compliant with DLT rules that are coming in from Europe. It would be actually more difficult for the traditional financial institution that wants to shift to DLT, that now there is a single framework that is not managed necessarily by the national supervisor. So I think that there might be some interactions, but this is all to be seen because it's just too early now, and the proposal is just a proposal. We have to see what comes out of the trialogues.
Thank you. We don't have any other open questions right now. I don't know if there is a last one that wants to be. Yes, we have one from Constantin. Thank you very much. Once again, regarding the reflection period, why does your statement not contradict with Directive 97/7 EC stipulating a 14-day right to withdraw?
As I said, it's a lex specialis. Directive is a principle-based legislation that is potentially applicable to all the framework. But if a lex specialis, so specialized law, comes in and defines the perimeter where different rules should apply, then those different rules prevail over also the previous European directive.
Very precise. Thank you very much, Diego.
I might come in, if I can come in with another one of my slightly more general questions. I'd love to hear, Diego, I thought it was very interesting, your comment about how you envision or tried to facilitate sort of one-stop shop platforms. That was actually the first time I had heard that view of the regulation. It makes a lot of sense. It's not something that has emerged much in the market so far. We tend to have our equity platforms and our debt platforms and various other verticals. So I think that's very interesting. I'd be curious though, from Diego, Delphine, Umberto, how, any other thoughts you have about how you think the crowdfunding market will develop as a result of the regulation? What do you think, when we're all back here in 2025, maybe actually in person in a nice hotel somewhere rather than on Zoom, and having the, whatever it is, 14th CrowdCon, what will we look back on and say, wow, how far have we come?
We don't usually regulate with the crystal ball, but we regulate with some objectives. And you are right. There is an idea of what we expect this regulation deliver. Certainly more cross-border activities, bigger platforms, more international platforms, and some level of cross-border activity, but also growth within the national market. Because we think we provide a framework that is solid, and is solid not just for cross-border proliferation of those services, but also within national. So we expect a bigger market and a more international market, a level of consolidation in the market. 2025 probably is very close, because if you consider all the derogations, etc., so we might end up having a fully applicable regulation in 2 years' time from now. Then you will need to have it, working out in the market. So I would expect that in the medium period, 5 to 10 years from now, we will have a market that is comparable to the one in the US and Asia.
Well, it's the same, of course. It's difficult to predict the evolution of the market. In France, we have hundreds of platforms. Only a couple of them are profitable. So, of course, at some point, it will have an impact either by the fact that some platforms will disappear. And it's also true, and we also have to admit that this regulation can, in a way, accelerate the fact that the withdrawal of some platforms, because, of course, it will imply costs to comply with this regulation, not really prudential costs, but as it was mentioned before, maybe legal fees to be compliant with this regulation. So, of course, as I don't think that the market as it is now, of course, will be the same in 5 years. But I am also very optimistic about the fact that this regulation will facilitate cross-border activities. So I'm also I really think that it will be good for a lot of platforms, and it will be an advantage if you want to compete with the US and the Chinese market, for example. Well, crowdfunding is a topic, if I can say topic, a way of financing close to the heart of the IMF and also the French government, as you know. So of course we will do our best to facilitate the implementation of this European regulation, and I really hope that it will help platforms for their development. So I prefer being optimistic about the future.
Well, in these difficult times, we all have to remain optimistic, because otherwise we'll just add to the growing numbers of depressed people. But anyway, just to close on a positive note, you know, we have answered all the questions. Thank you very much all for your participation and your time. This has proven very, very interesting, and I certainly, for myself, have had much insight into areas of the text which had not identified yet. Oliver, would you like maybe to say a last word?
Thank you. Yeah, but very short. So thank you very much to our panelists today and also the last few days. I think we had a slightly choppy technical setup throughout, but exciting and really intense discussions. I hope that the audience found some answers to their questions, and I hope that you you know, enjoy your break, and then next year you can start in earnest to prepare for ECSP, so that Diogo can, you know, in 5 to 10 years look back and say, this is what I worked on, and you know, this is significant today. Maybe just to look back at other industries that, you know, haven't managed to grow despite regulation. It's like venture capital has a very hard time. Here we have a microfinance, doesn't even have proper regulation. Angel investing doesn't have regulation. We have a fantastic opportunity here with a new market that is technology driven, that requires transparency and professionalism to actually shape access to finance for early stage companies, for innovations, for energy developments, for everything. And I think this is now up to the industry to make something of it. And I would like to thank really the policymakers in Brussels and in the member states like Delphine for their really hard work and open discussions over the last, tell me what, 8, 10 years that you engage in this sector, believing in something that didn't exist. And now where it becomes visible, still helping it out. So that's a good Christmas present, I think, a present for all of us. So for me, that's it. Thank you very much.
Thank you.
And then see you next year.
And happy holidays to everyone.